Okay, everybody, we do have 125 people who are online at the moment. So obviously large interest in our webinar today on understanding professional indemnity insurance. My name is Jill McCabe. I'm the CEO of Professionals Australia, and as many of you would know, we're a union representing professional employees right across the country. We have over 20,000 members, including engineers, and today's webinar is obviously of particular importance to our engineering members. And we certainly heard from our members that this topic was increasingly important to them. Thus, the webinar we've organised this afternoon. Before we start, I would like to acknowledge the traditional owners of the land across Australia, including the land where we are individually meeting today. I'm on the land of the Wurundjeri people of the Kulin Nation here in Victoria. I'd like to pay my respects to elders past, present and emerging, and to extend that respect to all Aboriginal and Torres Strait Islander peoples, including anyone who is joining us today. Welcome to Professionals Australia's webinar on understanding professional indemnity insurance. We're pleased you've joined us to learn more about professional indemnity insurance, which, as I mentioned before, is becoming an increasingly important issue for professional engineers, particularly those engaged as independent contractors rather than employees. Today, we're going to I suppose, provide you with up-to-date information about a topic that is impacting on your work, and that is really part of our role in representing and advocating for you, is to ensure that you have the information and knowledge you need about factors that are impacting on your roles in the engineering sector. So we really hope you find today's webinar valuable. It's going to be led by Lawrence Gottlieb, Manager of Professional Risk at Austbrokers Countrywide. And you'll also hear from Greg Hansen, Director of Professional Risk at Austbrokers Countrywide. Please use the chat function if you've got any questions throughout the session, and we'll address them in the Q&A a little later in the webinar. But if there are any questions we don't get to, we will compile these and respond to them and send them to you via email after the webinar. So now I'd like to actually introduce to you Lawrence Gottlieb, who is from Austbrokers Countrywide. There is Lawrence. Sorry, Lawrence, I was wondering whether you were available or not. I was getting a bit anxious.
No, sorry, Jill, here I am.
Oh, good. So Lawrence is a lawyer who's worked in corporate finance in South Africa before he moved to Australia in 2002. Since then, he's worked in a number of insurance brokerages and has over 20 years experience in managing professional risks, specialising in professional indemnity, cyber risk and managing liability insurances. So he's very well placed to lead today's webinar on understanding indemnity insurance, particularly as an engineer. So Lawrence, I'll hand over to you, and we will, after your presentation, also hear from Greg Hansen, who's the Director of Risk at Austbrokers Countrywide.
Thank you very much, Jill. I'm just going to share my screen now to get my PowerPoint up, which is not here. That's very strange. Bear with me 1 second. It was here a minute ago. Hang on 1 second. Sorry, I don't know what happened. I fixed this earlier. It is there. There it is.
And Lawrence, we've got a question in the chat around us sharing the presentation. So we are actually recording today's session, but I don't imagine we'd have any problems in sharing the presentation.
That is fine. That is fine. Thank you, Jill.
No worries. Thank you. Over to you.
Okay. Thanks very much for the introduction. Thank you to Jill and to Emma and Professionals Australia for organising this webinar, and thank you for all the participants who have logged in today to attend to listen to some insurance and risk management information during your lunchtime. I just need to get the How do I get this full screen? Sorry, I don't know. This thing's in the way here. How do I get the? I need to get up there to the slideshow. There we go. Sorry about that. Technical glitches. So today we're going to talk about what's happening in the professional indemnity market in Australia. I'm going to give you a little bit of background about why the market is where it is, what has happened, and where we are now in the cycle. But then I want to talk through some particular risks that you may come across in contracts, client-drafted contracts, and some tips to try and help you in wading through these contracts, some points to look out for in contracts about where they may impact on your professional indemnity insurance. There's a number of slides. You will have access to the presentation afterwards, so I will go through them relatively quickly. We're going to have some tips on managing your risk and what you can do to control the areas that you can control regarding your professional indemnity, your renewals and your premiums, etc. And then I'm going to hand over to Greg. He's going to talk about claims and run through some claims examples. So if we have a look at the Australian insurance market, it's important to note that it's driven by the local market and particularly by Lloyd's of London. For those of you who don't know, Lloyd's is not an insurance company. It's really a marketplace where many syndicates join together and form the world's largest insurance market. And Australia is actually the 4th largest market for Lloyd's in the world. So the Australian PI market is directly connected to the UK market, and the trends that we see in the UK often directly impact on the Australian market. So just briefly to put into context the situation we find ourselves in now, before about 2017, there was widespread overcapacity in the market. So there were high levels of competition. Many insurers were writing all sorts of risks. And what happened was they started writing them at what we call soft rates, which were unsustainable. So as a result of that, the market continued to attract new entrants, driving up competition and pushing down premiums further. Then from about 2017, there were quite a few more than usual natural disasters. And that pushed Lloyd's to a 2017 underwriting loss of $6.3 billion. And PI contributed about $800 million to that loss. In 2018, it was a further loss of almost $2 billion, $1.8 billion. So then Lloyd's started doing a whole review of all their underwriting, and they identified that international professional indemnity was the second least profitable line. So as a result, a number of Lloyd's syndicates exited the PI market, which resulted in reduced capacity, and particularly for the building and construction space. From 2019, the rapid decrease in capacity continued in the PI market globally, and those insurers that did remain have really pushed up premiums, pushed up excesses, imposed exclusions, and generally reduced their cover in their offerings. This is a quick slide on the insurance cycle. The insurance cycle is really a cycle like any sort of commodity cycle that you can think of. It goes up and it goes down. Insurers are like any business. They don't like to lose money. And when they start losing money, they take action by increasing rates and increasing premiums. So if you have a look at the soft market is when, as I said, there's extensive competition, lots of insurers in the market pushing premiums down, and as a result, the claims always come in. The premium pool is unsustainable to pay out all the claims, and insurers start making losses. Rates start to rise. Investment returns are also not attractive at that stage, and rates have to rise strongly, and then you enter into the hard market, which is where we are now, and becomes expensive. During that stage, eventually what will happen is capital will start flowing back into the market because insurers think we can now make money at these rates. They're more sustainable, and then rates will start to fall. So that is, in a sense, that hard market, the market cycle, which can take a decade or so to flow through and start again. So where are we now? we had a decade or more of the soft PI market until about 2019 or maybe a year or two earlier, especially for construction industry professionals. So as I'm sure most of you know, the market has hardened very rapidly over the last 2 or 3 years. Insurers have been getting a minimum of 10 to 20% rate increases, and in some cases a lot higher. We see some professions such as building surveying, geotechs, structurals, where rates are doubling or even more if cover is even available. And as well as the premium, we're seeing coverage is decreasing. New exclusions are being put on, excesses are being lifted, and limits are being reduced. So beforehand, an insurer might put out a $5 or $10 million limit. Now they may only put out a $2 million limit, for example, and we may have to approach other insurers to build up that limit if a higher limit is required. The slightly good news at the moment is the hard market. There are signs that the market may have peaked. It's not really softening, but we're not really seeing rates increasing anymore to the extent that we have over the last couple of years. And there are some signs that there are some Lloyd's syndicates who may be looking to get back in. So basically, just to recap, the underwriting losses became unsustainable. The worst affected really were the construction professionals, and particularly engineers. Structural and geotech engineers were the hardest hit. Electrical, mechanical, not as bad. Civil also quite badly hit. SCADA engineers also, quite badly affected. And building surveyors were probably the worst out of all the professions. Other surveyors not too bad. Architects as well. Of particular concern to insurers at the moment is any activities in high-rise, any projects in high-rise. They'll want to know the percentage of a high-rise, and most insurers classify high-rises over 3 stories, not 7 or 10 as they used to. So we've seen that coverage decreasing with, as I said, the higher premiums, the lower limits, etc. The whole cladding issue of a number of years ago is still yet to fully play out, and that is still having an effect on the market. Insurers are still seeing a number of cladding claims coming through. A lot of notifications were made some years ago, and now they're developing into full claims. So that really is taking quite a while to play out. Professional indemnity claims are long tail claims. They don't get resolved in a month or even a year. Often they take many years to play out. So that is still having an impact on the construction professionals market. So what can we do about all of this? A lot of these factors are out of your control, but what is in your control is your renewal process and the documentations that you submit. So here are some tips to help the process. Give the renewal process the attention it deserves. So don't wait to the last minute. I know everybody's busy and nobody particularly likes filling out forms, but it is important. It does impact on your business. So give it some early attention. Engage with a broker who knows what they're doing, who has the expertise and the resources in your field to provide you with proper advice. As I said, complete that proposal form early and diligently. If you put in a submission that is substandard, it really can prejudice your practice. It could result in premium loadings. It could result in higher excesses, particular exclusions, or even insurer declining to renew or to offer terms. If you can provide any risk management material, that is always good in this current environment. Include accreditations, manuals, certificates, etc. If you have risk management procedures in place, highlight them, give the broker a copy of them. Just try and differentiate where your practice stands out, if you believe it does. If you have had the unfortunate, if you're in the unfortunate position where you have had a claim or currently embroiled in a claim, provide as much details when it comes to renewal, particularly on the steps that you've taken to ensure that a similar issue won't happen again in the future. Insurers like to see what mitigation steps you've taken, what areas you recognized have led to the claim, and what procedures are now in place to make sure that it doesn't happen again. Sometimes claims are out of your control or not necessarily your fault, but try and address that issue if you can, particularly currently in the hard market. Okay, we'll now just talk about some contracts and go through some issues and some tips about what you can do when faced with a client contract, and this will help with general risk management. So it's just important to start with the common law position that engineers or all professionals find yourselves. So the common law position is that PI policies are designed to cover your civil liability, the civil liability you have at common law. They're not intended to cover all liabilities that you may agree to in a contract. So all policies have what's called an assumed liability or a contractual liability exclusion. And it's worth just reading through one of them. I've just picked one from a particular policy. So the policy will exclude any claim directly or indirectly based upon, attributable to, or in consequence of any duty or obligation assumed by and insured by way of contract, warranty, guarantee, or indemnity, to the extent that such liability exceeds the liability that the insured would have incurred in the absence of such contract, warranty, guarantee, or indemnity. So that is the premise that we're coming from. And this is what, when we look at contracts, we look at how they may impact on your professional indemnity insurance. So I've got a slide or two on all of these different clauses. I'll go through them relatively quickly because we want to make sure we have time for everything else, but you will have access to the presentation afterwards. So the first point is indemnities, which is very common. So an indemnity, or sometimes called the hold harmless clause, is a promise to pay compensation. So the common law position requires you to pay compensation if you breach a legal duty, i.e. if you're negligent or you breach your contract, and that is generally covered by your professional indemnity insurance. Any additional liability that is imposed by an indemnity that you agree to in a contract may not be covered, because it can often require a payment of a higher level of compensation than the law would normally require. So this risks infringing on that assumed liability exclusion that I read through on the previous slide. So what can you do when faced with an indemnity in a client drafted agreement? Best solution, which is not often possible, is obviously to delete it. Bear in mind that indemnities are lower risk if they require you to indemnify only when you've breached an existing legal duty, if they reflect proportionate liability and contribute to negligence, and I'll talk about proportionate liability in another slide. Contribute to negligence is purely that if the client contributes to the negligence, then that has to be taken into account in assessing your damages or your losses. And if it requires the indemnified party to take reasonable steps to mitigate its loss. So if an indemnity contains those, it's a lower risk. Indemnities about specific matters that are within your control might be also considered lower risk, such as intellectual property or moral rights. We often see those indemnities. So those are obviously lower risk than broad general indemnities about the whole of your professional services. Some insurers will provide an optional extension to cover your liability when you have to agree to these indemnities. And an example of this extension basically says that notwithstanding the contractual liability exclusion that I just read, the insurer agrees to indemnify the insured against any claim for civil liability that the insured incurs under indemnity, provided that the liability arises from the performance of your professional services. So if you ever sign an indemnity unrelated to your professional services, you certainly can't expect any cover. If you have such an extension, and it is within the professional services, that can give you a lot of extra protection. Speak to your broker and see if your insurer offers that if you need it. The next area is warranties, and we suggest you replace the word warrant with acknowledges and agrees, because warranties are often listed in that assumed liability exclusion as the type of the obligation that the insurer does not intend to cover. So you may remember in that example that I read, warranties, guarantees, indemnities were specifically mentioned. Again, warranties that are narrow and apply only to specifics may be lower risk than warranties which relate to your whole services. Standard of care. The common law position is that you must provide your services with reasonable care and skill. That is the standard that is demanded of all professionals, reasonable care and skill. So it's the standard of competence that an ordinary skilled practitioner in your field would have. So there's no requirement that you possess expert skill or you perform your services to the highest standard or you are the best engineer in Australia or anything like that. So any contractual agreement where you agree to provide your services at a higher standard could result in additional liability, which may infringe on that exclusion. So we suggest you delete those type of adjectives like expert or highest or high. And your client shouldn't have that much problem in deleting that. Insure clauses, again, clauses that require you to ensure a particular outcome, essentially demanding a higher standard of performance and really amount to an equivalent of a guarantee. Again, repeating myself, but it's likely to infringe the assumed liability extension. If you have some control over those matters, it's less risky. But if they're outside of your control and you agree to insure that particular obligation, that's a higher risk. So we recommend replacing the word insure with, take reasonable steps, etc. Back to the proportionate liability issue that I raised earlier. Proportionate liability provides that a party's liability for damages be limited to that portion of the damages for which you are responsible. Now that sounds fair, and the legislation was brought in just exactly for that, because without that protection, you could find yourself in a position where you're jointly and severally liable with other parties in a project, even if you didn't contribute to that loss, or even if you contributed a small percentage. So the protection of the proportionate liability legislation essentially says, if you are 10% responsible for causing a loss, you should be held 10% liable. Without that protection, you may be fully jointly and severally liable for that 100%. And if the other parties are, let's say, in liquidation or don't have insurance, you could find yourself or your insurer bearing the whole amount of the loss. In New South Wales, WA, and Tasmania, you're allowed to contract out of the proportionate liability legislation. Queensland, you're not allowed, and Victoria is a bit of a grey area. Now, we find that government contracts are actually one of the worst offenders in asking consultants to contract out of this legislation. You should always push back and delete those clauses and say to your client, you're not contracting out of that legislation because it's there for fairness, and why should you be held responsible for other parties' losses? If you have to sign up to that agreement and you can't get out of it, again, some insurers will provide an optional extension to cover that liability, not all, and it comes with an extra premium. So speak to your broker if you need it. But the first point is really to try and delete it and have a conversation with your client that why are you looking to contract out of the legislation that is particularly there to protect us. What we're finding is a lot of client drafted agreements, their lawyers just try to push down as many obligations to the consultant as possible. And this is one example. Very quickly, liquidated damages are common in building contracts that don't belong in consultancy agreements. Don't agree to sign up to liquidated damages. In case you don't know, liquidated damages are really predetermined damages, so such as an agreement to pay $1,000 per week or per day if certain events don't happen. They risk infringing your assumed liability exclusion if it found that those liquidated damages are greater than the client would have been entitled to without that liquidated damages. So just delete those clauses, don't sign up to them. Professional indemnity insurance policies aren't designed to cover liquidated damages. They really belong in building contracts. Waiver of rights and releases. Contractual obligations which release the client from any future claims. We see this quite often. Again, likely to infringe on the waiver of rights exclusion. So when a client says they demand in the contract to be released from any future claims, don't agree to that. They're not releasing you from any future claims. And then what happens then is if you agree to that, insurers may be prejudiced. They won't be able to recover any losses from your client or from third parties. So delete those clauses, or if you can't, try and water them down a little bit by only including them if claims for your professional fees or similar expenses. So the release is a bit more narrow. You may have to get legal advice if it's a significant contract and there's quite a few of these issues. We always recommend getting some legal advice as well. Limitation of liability. Do not allow your clients to limit or exclude liability. This could result in the waiver of rights if that liability would have been partially or fully recoverable. So what happens, a client often says that they limiting their liability to you to a particular low sum, and then that again could cause trouble because your insurer won't be able to subrogate or to recover any further funds from that third party. So any cap on that liability could prejudice that insurer's right of subrogation. We often see the obligation to maintain insurance in contracts, where the contract requires you to maintain a particular limit of professional indemnity insurance for, say, 7 years after project completion. As you all know, professional insurance is annual. You have to renew it each year. And particularly in the hard market, you can't be certain that you can obtain cover on similar terms or with that particular limit. It may be too difficult, it may be too expensive. So add to that clause, subject to continuing availability upon reasonable commercial terms. And again, that shouldn't be too much of an impost on your client. Watch out for clauses which says that you limit your excess is only allowed to be a maximum of a particular amount, say $5,000 or $20,000. Excess levels are often out of your control. They're set by insurers, and clients shouldn't really have any input into that. Similarly, if the client wants to have approval of your PI policy, insurers can't change your policy to meet the requirements of one client. They cover all your projects. So delete those clauses which give the client the right of approval over your PI insurance. Similarly, also don't agree to clauses to keep client informed of developments regarding a particular claim on the project, or at least if you can't delete that, include there that you won't provide information if it could prejudice the defense of a claim. Because if your client is suing you on a particular project, your insurer won't want you to keep them up to date on your defense, obviously. So what happens if you try all this and your client says, well, they won't amend the contract, take it or leave it. Nobody wants to walk away from work at this stage unless it's a really such an egregious contract that you say, I'd rather not do the work. So if you sign an agreement with, let's say, an indemnity in it or one of these other areas that I've covered, it does not mean that your insurance is void, okay? In the worst case, you could be wholly or partially uninsured, but for that to happen, all these three things have to occur. So obviously a client has to make a claim against you on the project. The claim is based on a particular unamended clause specifically, and the insurer takes the view that the unamended clause has given additional liability compared to what you would have had if you hadn't agreed to that clause. So unless all three of those things happen, the decision not to amend the clause will have no impact on your PI. So for example, when we look at clients contracts and insurance contracts and give them advice on any PI implications, we don't advise the insurer of that contract. Insurers won't look at contracts and comment on them. And the insurer doesn't penalize you in any way for not amending a contract because they're not involved in that process. And you'll only be in a prejudicial position if all those three things happen. So it's not It certainly doesn't mean your insurance is void, which is the key point, which sometimes the question we get. So just finally in my section, just some tips for managing the risk. If you can, use your own terms and conditions or industry standards, AS 4122 and other industry standards where you can. Often that's not possible because clients, specifically on larger projects, engage their own lawyers and they want their own agreements. Ensure you have appropriate quality assurance systems and processes in place. Include where you can limitations of liabilities. If you can limit your liability to, let's say, the limit of your professional indemnity insurance, at least then you know that if there is a large claim and you only have a $1 million limit, the insurer will pay up to that limit if you have limited your liability there. Very important to keep good records of any contributory negligence of any other third parties or any failure by any other third parties to mitigate the losses, so that in defending a claim, you and your solicitors and your insurer can raise those issues that, yes, we may have contributed, but there's been other contributors to those losses. And as I said, really obtain some legal advice, particularly for any large or complex projects. I'm now going to hand over to my colleague Greg, so you can hear another voice to talk about claims examples.
Hi all, I'm just going to have a quick chat about key exposures faced by engineers and run through a couple of claims examples that we bumped into. Oh, okay. Just quickly on this list here, just a broad list of where we see claims against engineers. To pluck out a couple, one that talks about poor work documentation. In the event that you do run into a dispute over a job and it turns a little bit nasty and lawyers get involved, the solicitors will always tell you that it often can boil down to documents. So the tip there really just is the better your documentation, even all discussions, taking notes, keeping diaries, dates of discussions and what's happened and anything that's changed. The better your documentation is, if we get in an unfortunate situation where everybody's suing each other, the lawyer to a large extent looks at your file and is reliant upon your file, not a conversation that might have occurred. So the better your documentation is, the easier it is to run a defence. Outside of that list, often I'll get asked what are insurers worrying about now, and probably the two areas we get asked about. One is sort of the cost of business interruption arising out of your services or your design. So if you're a SCADA engineer or you're an engineer involved in production lines, the way the insurers think is if that production line halts, is it $1 million in revenue a day that gets held up? So they're immediately thinking about loss of revenue and cost of an interruption. So if you can help explain how these sort of risks are managed, or that a cost of an error isn't so disastrous as $1 million a day, it's back to Lawrence's earlier point that it helps with your renewal premium, because the insurer gets a better idea on the cost of an error or potential cost of an error, and anything that you do to help manage cost of errors. The other area that insurers are red hot at the moment, which is in the news, it's just the economic downturn. Insurers at the moment are concerned about builders going broke. So builders that sign design and construct contracts and then push the design down to the engineer and the architect and the surveyor. Insurers now, which they never used to do this, are asking us for copies of financial statements from builders and information about fixed price contracts from builders, because the insurers know that if sort of a builder goes broke, then there's a lot more pressure on the design consultants with errors that might arise out of that project. That's the other thing where we're getting asked a lot of questions about. This is just a quick claim example. We had an engineer, they designed tank foundations and a piping system for a large diesel tank at a petroleum site. There were separate entities doing design and construction work and the tank painting. There was talk of postponing painting due to bad weather. A storm went through and the tank roof collapsed. The tank vent had a temporary sock that was supposed to be removed overnight, and the expert report came back and said that because it was not removed, the negative internal pressure caused the tank collapse. Now, the total claim to fix all of this was $5.5 million. The engineer who was involved from our end, to some extent, the litigation got a little bit messier, and it's back to Lawrence's point about contracts, is they thought they were primarily involved on a design basis, but the contract had also assigned project management / construction management responsibilities for that engineer. You know, you'll conduct supervision, you'll conduct inspection services. So in the end, proportionate liability applied, but because the engineer was deemed to be carrying a project management role in addition to the engineering role, it increased the amount of payout that engineer had to pay to settle the claim, as opposed if they were just a design consultant. Second claim example, it was a small one-man band mechanical engineer. He got involved in a large construction project. It was up in Queensland, and an airport runway and a hangar and a very large construction project. But our mechanical engineer was just a sub-consultant doing a very small component. It was a platform that raised and lowered inside a hangar. There was a large claim, a dispute, I think it was between Multiplex. Qantas was certainly involved, but because it was such a large project and our engineer got named and joined into it, this was before he had protection under proportionate liability legislation. So it backs up Lawrence's comment to try and not contract out of proportionate liability. But he got stuck on the writ for something like 2.5 years while all these parties had lawyers and spent money. And the insurer spent almost $200,000. It wasn't in excess, it was just a bit below that, of actually getting the engineer off the writ. And none of that was refundable, because usually these large litigated cases, everybody wears their own legal defence costs. But it's an example of where an engineer hadn't done anything wrong. He had a very small project attached to a really big, large infrastructure project, and the litigation of the large project, he ended up getting sucked in and just relied on legal defence costs under his professional indemnity insurance. My last example, we had a civil engineer and the insurer had been insuring them for at least for a decade. They on their proposal form, over 80% each year they'd consistently declare was road design, road safety audits, traffic engineering. They took on a project that involved the development of an apartment block, which included geotechnical services. So they took on the whole project and outsourced the geotechnical component to a small sub-consultant who didn't have PI insurance. So they included him under their cover. Lo and behold, a claim came in, and the problem was 100% around the negligent provision of the geotechnical engineering services, which caused significant delays, and the claim ended up costing $1.2 million. This put severe distress on this consulting engineer's policy. He'd been with this insurer for years. The insurer paid the claim, but the insurer didn't really like the idea that they'd had this design engineer, primarily their specialisation being in road design, safety audits, pick up a geotechnical engineering risk that was really, and even a project that was probably really outside their area of specialisation. So their professional indemnity premiums were significantly more expensive for many years after this claim, which you can imagine. Yes, the insurer did agree to cover the geotechnical engineers. I wouldn't say they were 100% innocent, but it's a good example perhaps of an engineer stepping outside their core business and what they're really good at, and a claim that went wrong that just caused havoc then for that engineer in terms of just buying their insurance for many years thereafter. That's the end of my little piece, just on some where we see claims and some claim examples. These are contact details for me and Lawrence, which will get distributed. I was just going to pass back to Jill and see whether there are any questions or queries that have come in via the chat function.
Yes, thanks so much to you, Greg and Lawrence, for that really informative presentation. Obviously covered a lot of territory there, and it's quite overwhelming for someone like me, and I'm sure that some of our participants today have more questions as a result of the presentation. So they've actually put some into the Q&A function in the chat, so let's get stuck into those. The first question here is, if you've closed your business and you're semi-retired, you're now working as an employee for a couple of previous customers, what insurance should you consider now and for the future? Any of your designs have been proven or not reassessed. So I think the position here is that this person's now an employee, not a contractor as such.
Okay, all right, I'll start. If you're closing your business, we recommend taking what's called run-off insurance. So that covers all your past liabilities, but no work from a certain date, date in time going forward. Some insurers will offer a multi-year run-off. So in other words, you can buy a 7-year run-off policy or a 5-year run-off policy at a discounted rate, and that period is locked in for the number of years. But there are many insurers who won't do that, and they will only do run-off policy on an annual basis. So the run-off in the first year, if you're closing your business, the run-off in your first year will be the same premium essentially as you paid previously, and then it'll start tapering off in the forthcoming years. If you've closed your business already, you can't take run-off a few months later or a year later, because no insurer will do that. You'll have to do it with that same insurer who was insuring you at the time. Instead of renewing as you normally do, you would speak to them, and you would then put your policy into run-off.
Yeah, and my only tip on that is for engineers to plan this. If you're a consulting or you're a contracting engineer, when you end, you really need your insurance to continue for 6 or 7 years, not 1 year after your last job, whether you're switching to be an employee or whether you're retiring. And if we can package up the 6-year policy, a rough guide is, if it costs you, I know it's more than this, but $1,000 for a 1-year policy, it's usually about $3,500 for a 6-year policy. So you get a discount, and you can package up your run-off cover across 6 or 7 years with a number of insurers. So you almost need to plan you're going to get this bill as soon as you stop consulting.
And it's also worthwhile checking with your broker if that particular insurer will offer multi-year run-off, because as I said, a lot don't.
Okay, thank you very much for that. The next question is about if you're working as a freelance consultant in engineering and you're working across different geographical boundaries and jurisdictions, what's the nature of the professional indemnity insurance you should be taking out, and are companies providing cross-border insurance? What's the sort of state of play when it comes to that international provision of services and the insurance product that will cover you?
Yeah, it's really common for us to deal with that. So we also do a scheme for mining consultants who work all over the world. So it's often insurers will just cover you worldwide, excluding USA and Canada. So they pick out USA and Canada and exclude those two, but cover you everywhere else. So you need to make sure your insurer is covering all of the countries that you're working in. And the other issue is that's territorial cover. The other issue is just jurisdictional cover. So we have some engineers that do work overseas, and they sign up to an overseas jurisdiction. So they're saying, oh, we're happy if we get sued in a UK court. So then we need to make sure the insurance covers overseas jurisdictions as well. So you need to give us a clear picture on which countries you're working in. and also where is a dispute going to be settled? Can we drag them back here and have the litigation back here, which is preference, or do we have to front up in a foreign court? But it's a common issue we deal with, and it is easy to generally buy insurance for overseas work.
Okay, thank you. We probably won't have enough time today to go into why the US and Canada are excluded, but it's probably because of high litigation in those countries.
I'm not sure why they lumped poor Canada into it. But
that's what I mean. Yeah, it's interesting, isn't it? Yeah. This one again goes into that 6-year runoff for PI insurance. So would you be able to shine light on the runoff periods and how they work and apply? I have a requirement of 6 years run for professional indemnity, with the reasoning being in case you leave the profession. So I think you've covered that.
Yeah, it's where's the 6 years come from? I think historically statute of limitations in each state would say, you know, you can be liable for up to 6 years after you give some advice or do some design work. So it's common for contracts to say, buy PI insurance, but you also need it in place for 6 years after the contract ends or your work ends. So that's quite common. But that's not an exact science. In Victoria, the Victorian Building Act says you can be liable for 10 years after a building is built, and 15 years if it's a cladding claim. It was nice of them to change that. So the 6 years just comes from that historical statute of limitations period that most states have.
And just finally on that runoff, it also depends on the sort of the risk appetite of the practitioner. So we get some instances where insured might take runoff for the first year and the second year, and then after year 3, they come and they say, look, we are very confident in all our projects. We don't want to pay any more money. We don't want any further runoff. It's nothing to do with us. We don't say, yep, you need it. We recommend you obviously have it. But if the risk tolerance is such that, you know, that you can sleep well at night without the runoff, then that's entirely up to that
the individual. Yeah. And I think we've covered this too in terms of that case study that you gave, Greg, around professional indemnity covering legal or arbitration costs. Do all of the policies cover those?
Yes. Yeah, it's just stock standard to cover legal costs. Yeah.
Fantastic. And again, this is another one about the 6 years continuation. Can you buy it as a lump sum? And I think you've already covered that, Greg. I suppose it depends on the companies and whether they're up to that multi-year approach being paid off. So, and do you assume the premiums reduce as time passes because the risk diminishes?
Yep. They do. So if you buy annually, the premiums reduce after year 1. And if you buy it as a block, they build in a bit of a discount for your 6-year policy.
The only qualification I would add is if it's a small practitioner and they are not close to the minimum premium an insurer will charge, then they won't reduce below that minimum. So let's say $5,000 is the minimum they charge for a structural engineer, regardless of the fees, the annual runoff will still stay at that $5,000 for every year.
Yeah.
The other question is, what's the range that you're looking at in terms of the cost of professional indemnity insurance at the moment annually? And I know it'll probably vary according to the type of engineer you are.
Yeah, I'll give you a couple of examples and Lawrence will have a few. We used to be able to buy PI insurance for a structural engineer for about $3,000 a year. And I think since 2019, the $3,000's gone to 10, like it's times 3. And the insurers now are just saying, if you're a structural engineer, we just start at 10 grand. I'm adding on GST and stamp duty, but that's pretty much just a minimum premium. Geotechnical engineers have suffered from the same sort of fate where we just can't find insurance under $10,000. And if you're a big geotechnical firm, that doesn't hurt. But if you're a small consultant, that obviously hurts. But we still get quite a few mechanical, electrical, civil engineers paying $2,500 to $5,000, I suppose, for their PI insurance as a bit of a range, depending on the sort of work they're doing. But the premiums really do jump around a lot, depending on the profile of how you describe what you're doing. And that's why we talked a little bit earlier, is to try to get around the insurer deciding that you do scary work. sometimes us having a chat about what's the consequence of a loss, what things do you do that manage risk, and we explain it to the insurer better, that can help you come up with a better price at the end of the day.
We're just looking at, I suppose this goes to a question that a few people have asked about. What if you work in local government? So if you're an employee, for example, as opposed to a contractor. And then we've also got a question here about graduate engineers in startup companies where they may not be doing entirely engineering work. Are there any resources relating to engineering insurance specifically tailored for graduates or startups?
You can grab employees and I'll grab graduates.
Okay. Right, so all PI policies cover the insured entity, the legal entity if it's a company, and all directors and employees. Right, so they're automatically covered. It covers all employees, even if they leave and a claim and directors and a claim comes in afterwards, as long as the insurance is still in place. It's very, very, very rare. In fact, we never see it where an employee is named on a writ or in a claim. It's always against the company. Very occasionally, one of the directors may be personally named as well. Okay, so if you're an employee, your employer has insurance and you're automatically covered. You don't need to take out your own insurance. In fact, you can't. Nobody will insure you. If you're doing private jobs out of that, that's a different story. If you're working for municipal government or any company, you're covered under their policy, as long as that policy is still in place. Yep.
Yeah. If you work for a local council, same principle. You're covered as an employee by the local council's insurance program. And I know people worry about it when there's a registration regime comes in. They worry about whether they have a higher personal liability. And our argument is they don't. They're an employee, whether there's a registration regime or not. The employee is protected and covered by the employer and their insurance program. The graduate engineers, a bit the same principle in that it's expected by the insurers that graduate engineers' work is generally under the supervision and control of a qualified engineer. So no matter where they land or where they work, they're automatically covered again under that company's professional indemnity insurance policy. And even if the graduate engineer did something wrong, it would still be covered because the company would be liable for the activities of the graduate engineer. And it would be expected that the company should have supervised and controlled and or signed off anything that was done by the graduate engineer.
Yeah.
So we've covered a couple of other questions, which is, again, working as an engineer in local government, will that also allow me to have insurance? I think we've covered that. So professional indemnity is really where you might be doing private work. So you've got your own business, you're doing consulting or contracting out. So, yep. Yep. Another interesting question, which does go to the issue of registration. So if, and it goes to your presentation earlier, Lawrence, about what information you provide to an insurer, which demonstrates that you're a lower risk, I suppose, to that insurer. So all other things being equal, would an engineer who's received registration likely obtain cheaper insurance than one who is not registered? You'd hope that it'd be a positive factor that that the insurer would consider.
It's certainly not going to hurt in this current market. I don't think you'll get a discount when it comes to renewal. They may look upon it favorably, and without it, they might have said, well, we may be loading your premium a little bit, or why aren't you being registered or something? But I don't think you can expect, unfortunately, to see any, significant, premium reductions after registration.
Yeah. Insurers generally like professions that have registration, which means more regulation and usually minimum professional standards or minimum qualifications. It's only a personal view, but I think under the Victorian Building Act, when they started registering practitioners and they totally left geotechnical engineering out of it, it probably only, and this is an old comment that happened in 1993, it probably didn't help geotechnical engineering because the insurers got more confidence in the professions that were registered and they felt like were more regulated. So insurers do like registration regimes and regulation because they think that you can't just have any backyard practitioner set up and go. In principle, they like the idea.
Yeah. We've got a couple of other questions here. Do we have a SCAD claim example? So I'm not quite sure what that is. SCAD.
SCADA. Must be SCADA, SCADA.
Oh, SCADA claim example that you could share at some point. So that might be something we can take on board.
Yeah, get that person to email us or we'll just circulate this. The reason we highlighted SCADA is how I described that business interruption risk. So sometimes it's even a software engineer, and if the SCADA is involved in manufacturing or where we've seen the bigger risk mining and processing of iron ore and things like that, if the consequence is that there's a production line breakdown and there's high revenue losses for every day the production line's down, that's what the insurer worries about on the SCADA engineering side is the automation. If they're in charge of automation and automation stops, production line stops, the consequential financial loss can be high. So the SCADA engineers need to be good at explaining what type of work they're doing. And if we can, we explain to the insurer how those sorts of risks are mitigated or minimised.
Yeah. And just quickly on that point, if you are involved in that type of work, watch out because sometimes insurers, when they offer terms, they will have a consequential loss exclusion. So they'll exclude that, all those, the loss of profits, that business interruption that Greg's been talking about, which is not ideal, obviously, for that type of work. So watch out for a consequential loss exclusion by way of an endorsement on your policy.
Lawrence and Greg, have you got another 5 minutes? Because we do have quite a few questions. So I think we can perhaps run through a few more and then any that are outstanding out of that, we might be able to then, as I said, provide some written responses to, but I might try and get through a couple more. So this is the issue. What if my client covers my PI insurance, but discontinues the professional indemnity once the project is finished? After the project is finished, do I take out my own PI?
Yeah, that's the concern of that process. We do bump into this a bit with, Professional Australia members, where they might be a sub-consultant under the job. Oh, I don't need insurance because, my client or the engineer, who's engaging me is insuring me. And we usually say, listen, that's fine, but proceed carefully, i.e., you want proof for them that you actually are on their policy because you're not an employee of theirs, so you can get joined in. And what's your protection that you are covered, as you said, for the next 6 years? So 2 years down the track, there's a problem. The lawyers often will just go, well, were there any sub-consultants or contractors on this job? And we often see it where they just name everybody. So I think if you're relying on someone else's insurance, you need a proof that you're named and something in writing from that you'll continue to be insured by them for an adequate period. Often the easier way to go is to have your own insurance. So it can be a bit fraught with danger relying on that.
Because if you take insurance for the first time, then that policy will inevitably not cover you for any work that you've done previously. It's only going to cover you from that inception. So it'll be difficult to get cover for work you've done 4 years ago that you weren't insured for at the time.
Okay, the next question is an interesting one. How does PI liability sit with an engineer who's responsible but not accountable for their work? So that probably, I don't know whether Akalish has any further comments that they want to make about that.
The only comment I'd make in the meantime is we're almost back to that employee versus contractor. We'd argue, we had a claim, I'll give you an example of responsible and accountable and how you use the words. We had a claim where one engineer designed a walk bridge over not the Yarra River, but over a river. And he asked another engineer at a barbecue whether he thought the design was adequate. And the other engineer had a bit of a look and they had a bit of a chat about it and didn't get paid a cent for it. The bridge collapsed and the other engineer from the barbecue got joined into the litigation. And he thought he had no liability because hold on, I didn't get paid for the job. And basically the way the law works is if you're a professional and they know you're a professional engineer and you're happy to attach an opinion on something, you don't necessarily have to receive a fee. So we'd argue that you are probably responsible and accountable on the basis that you're a contractor and there's nothing that stops another party to join you into a piece of litigation.
No, I'm not sure there is such a thing as responsible but not accountable. I don't think that's a thing.
We've just talking about insurance for consulting professional environmental and sustainability consultants. Again, I imagine that we'd still, professional indemnity insurance would still be important there, and whether the amounts would be substantially different from what you've talked about today in terms of, you know, some of the engineers having to pay $10,000 per annum.
Yeah, go.
Yeah, listen, we definitely get, it's probably a growing field where we get a lot more inquiries now. But as soon as you mention that word environmental, it can be, I had an inquiry yesterday and all he was really doing was a lot of data analysis for surveys. So it was more the mathematical data analysis component, and he didn't have any responsibility for environmental, you know, compliance or auditing. But we're getting more and more inquiries for insurance, and it's quite common, and insurers are quite happy to cover these things. They'll look at the environmental risk. They'll go, well, is this sort of toxic material that you're assessing that might be able to flow into a river, high risk? Or is it more like my earlier example where the guy really is just analysing some data for a government department? But it's a common area that we're offering professional indemnity insurance quotes to.
Steve is putting a question here about what happens if you're an employee and your business doesn't have the insurances. What's the situation there? And do employees obviously need to check that the business is covered? Again, I suppose this depends on where companies decide to take litigation against particular organisations, and is it really at the employee level that they'll pursue damages, or is it at the at the top end of the business?
Yes, as we said, it's almost it's unheard of essentially for an employee to be dragged into one of these matters. If the firm doesn't maintain insurance or closes down and has no runoff, they can, in certain circumstances, especially if it's a large claim, the claimant can look to pursue the directors, especially if they think there was some, you know, not for misrepresentation or fraudulent activities going on. If the company's in liquidation, they can try and jump through hoops and get the company reinstated, which is not easy, but it can be done in certain circumstances, and they can look to hold the directors personally liable under certain circumstances. But the employees, we've never seen where the employee gets chased in those situations. And if you are an employee or an ex-employee and the firm doesn't carry insurance anymore or doesn't buy runoff, there's very little you can do. You can't take out insurance to cover all those past liabilities. But I think you can be rest assured that the chances that you'll be held liable is extremely remote.
Yeah, with building surveyors, because they've had so many problems off the back of non-compliant cladding or flammable cladding, now it's common for a building surveyor to join an employer and ask for proof of professional indemnity insurance and that they're covered. So I have heard of employees that check. I don't have a problem with that. I think they're extra nervous just because there is a lot of litigation out there against non-compliant cladding. So there's no harm inquiring with your employer if you're a professional that they've got appropriate professional indemnity insurance in place and to check that you're covered. But as Lawrence says, I've never seen an employee litigated against, but I have seen directors, if the entity's been closed down, they've chased the directors. It makes more sense for a lawyer to chase a director than an employee.
And for registration purposes, the employees who registered will have to provide evidence of insurance of their employer's insurance to that registration board. So you'll see it there anyway.
We've got one, we'll do one last question. Our PI only covers civil engineering and project management. As part of a small job, we subcontract to a structural engineer who holds their own professional indemnity insurance. If anything goes wrong with the structure in the future, would the RPEQ structural engineer who was working as a subcontractor be responsible, or would it be the engineering consultancy that issued the invoice?
I can start with that one if you like. I think because they've taken on a contract that has structural engineering responsibilities, even though they've passed them on, they've taken on the contract, so they've got the initial liability. So I think it's probably important that they need to go through and declare that to the insurance broker and declare it to the insurer, because you wouldn't want to be in a circumstance where a claim arises. The claim's around structural engineering risk, and the insurer goes, well, we're not covering you for structural engineering, we're covering you just for civil engineering. So that's something I'd encourage the engineer to contact the broker and pass on. That matches that claim example I had where I had a civil engineer who took on a job with a geotechnical component. They contacted us, the cover was arranged, and then the claim was all around the geotechnical component. I'm really glad they contacted us, because I think it would have made the claim a lot more messy if we just had 6 years of proposal forms that said all they did was, you know, civil engineering and there was no geotechnical engineering declared. So when it is an extra different function to what you've declared to insurer, it's worth going back and getting cover clarified.
Yeah.
Okay, well, I think it's 1:40, so we have run over time, and a few of us have got other meetings to attend this afternoon. I think we can see from the questions that have been asked today and the number of people who've attended today's webinar, you know, really strong interest in this topic. Obviously, we'll, as I said, be sending the slide pack out to the participants. We'll also provide the recording, and we'll package up some of the outstanding questions with some responses. We'll also do a bit of a survey of the participants today to see if they actually want to conduct another one of these webinars, because there's obviously a lot of information to digest and get your head around. So a huge thank you to both Lawrence and Greg, as they've demonstrated very ably today. They really are experts in this field. So thank you for sharing all of your knowledge with us today. And you can see in the slide pack that goes out, there are both Lawrence's and Greg's contact details as well if you've got further questions you wish to ask. So thank you to all of you also for attending during your lunch break. We greatly appreciate it, and we'll look forward to communicating with you again in the future. Thanks again.
Thank you.
Bye.
Thanks, everybody. Bye.